The next matter to come before the court this morning is all Type Demolition and Excavating versus DiBenedetto et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve time for rebuttal, you let me know when you get started on keeping the clock this morning. Can keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Initially, I'd like to point out that this is a de novo review of a grant of summary judgment on all the plaintiff's claims. Under Rule 56, all doubts and evidence must be construed in favor of the plaintiff, and all reasonable inferences should be allowed to the plaintiff as well. Plaintiff's amended complaint alleged 5 counts of action: breach of contract, promissory estoppel, unjust enrichment, spoliation, fraudulent conveyance. The DiBenedettos, there were 3 parties in this case: Sparky Development and Anthony DiBenedetto and David DiBenedetto. Only the DiBenedettos moved for summary judgment, and they did so on only one of the claims, and that was on plaintiff's breach of contract. And their sole grounds for their motions for summary judgment on that ground was that they argued that they did not sign Exhibit 2, which was an October 8, 2007 contract, as owners, but as agents of Sparky Development. And they simply supplied a self-serving affidavit, each of them, to that effect. Plaintiffs submitted affidavits that hotly contested that claim and submitted examples of the contracts that were signed. And there is more than a little ambiguity in the way these contracts are signed. Tony and David are listed as owners and David signs as owner. So we have that ambiguity as well. And furthermore, as the evidence developed, it turns out that the demolition of the North Ridgeville Shopping Center was not carried out under either Exhibit 1 or Exhibit 2, the written agreements, but rather it turns out it was carried out under an oral agreement entered into at the end of January or early February of 2008.
What in the record shows that? What in the, because we're selling summary judgment, so
right.
Other than affidavits, do we have deposition transcripts that were filed in support or opposition?
You raise a good point here. No, there were no depositions filed, not Mr. Fossey's deposition, which the appellee claims is inconsistent with his affidavit. But the fact of the matter is that Mr. Fossey's deposition was never filed with the court. And really is not before this court either. His affidavit is. Now, I don't read his affidavit as inconsistent with his deposition. His affidavit establishes, hey, look, we didn't tear this center down, or All-Type didn't tear this center down under these written agreements because they had expired. They had expired by their own terms no later than January 10th, 2008, and the DiBenedettos had not done any of the conditions precedent so that demolition could start.
And the affidavit is consistent with the complaint? Because it doesn't matter whether it's consistent with the deposition, it's not in the record. Is the affidavit of All-Type or both of them consistent with what was pled in the complaint?
Well, there are additional facts that have been learned. Yes, I think it is consistent with the complaint. But there were facts that were developed beyond what was in the complaint. It's consistent with a breach of contract action. But it turns out that really what's happened here was this was performed under an oral agreement. So there are some differences between the complaint and the affidavits, but not substantive material differences, just those that would reflect the evidence. And neither of which was refuted. The the DiBenedettos had the opportunity to submit counter affidavits. Their affidavit said one thing: we were just agents here, we were not the owners. Now, that's all their affidavits said. But the court then, without even being asked to grant summary judgment on plaintiff's second through fifth causes of action, grant summary judgment on all causes of action. Now, when you deprive a party of their constitutional right under the Ohio Constitution for the right to a jury trial, there are certain threshold limits, threshold events that must occur. And those are laid out in the case of Drescher versus Burt, and Vahila versus Hall, and Mitzef versus Wheeler, which puts the burden on the party seeking a motion for summary judgment to identify the grounds that they're seeking summary judgment on, to inform the court of the basis of its motion, and to present facts in the record or facts not in the record that create an absence of a material fact and issue. Now that's the burden. Now in this particular case, the defendants never mentioned counts 2 through 5 when they were seeking until their reply. And I pointed out in my opposition to their motion for summary judgment, I pointed out to the court and to opposing counsel, saying he has not moved for summary judgment on counts 2 through 5. Therefore, but in his reply to that, in his sum up, he says, oh no, we are seeking summary judgment on all counts. But still, nothing is presented on the grounds as to why he's entitled, or facts or omissions, and he's relying on depositions that weren't filed in the case. And the affidavits, taken at face value, create material issues of fact. You know, certainly on the four causes of action that were dismissed without having been moved. And as for whether or not...
So what was left again?
I'm sorry, what?
What was left after summary judgment?
Nothing. Nothing.
I'm getting confused.
As it relates to these defendants.
As it relates to, yes, I am sorry, Your Honor, I misunderstood you. But as Sparky Development did not
Sparky Development was still there,
yes, on all counts.
but everything from you guys was gone.
Everything from the DiBenedetto brothers was gone, yes. Yes, so that was it. And I think there were just certain as I said, threshold events which must occur, and the court's error in this case was not to hold the defendant to his initial burden, at least on the 4 counts that he didn't move on, of identifying the basis for the motion for summary judgment and presenting for the court's consideration that evidence which was in the record, which should have been in the record, that created an absence of material issue. In fact,
Let me just, the reason I started along that line of questioning is because if the court dismissed everything that you had against the 2 brothers, all right, but they had moved for summary judgment on the breach of contract.
yeah.
Let's say, hypothetically, that the case is in front of us correctly, that you were able to appeal that because of the 4B language you were tying with. And then they did move for summary judgment on the breach of contract, but since they did not move for summary judgment on the others, we would be reversing those. Would we still be able to look at the breach of contract summary judgment ruling? Or should we send it all back, or what should we do?
Well, I think you should reverse the judgment of the trial court on all counts.
And why is that?
And
Because they did move for summary judgment on the breach of contract.
right. And
I mean, aside from the merits of it,
Yeah.
I'm talking procedurally.
oh, procedurally. No, my argument on the grant of breach of contract, it is on the merits. I'm not. I
Well,
don't
the
think
reason I'm
claiming-
asking is because this court has struggled with this issue. If they look at one issue and they don't move for summary judgment on the other issues, are they intertwined in any degree? Or should it be a package deal? Or does this affect your other claim against Sparky? Those type of things.
Well, if you're asking my opinion.
Well, that's why I'm asking. I'll give him an opportunity too.
No, I think in for a penny, in for a pound. I think you decide all issues. And if it goes back, let's look at it as a practical effect. If you were to say, okay, look, they didn't consider we're sending it back, are you sending a message at that time that the court should now consider those causes of action again, whether or not they should consider summary judgment? That'd be a terrible prejudice to me to have to go through that procedure again. I think the defendant here has filed 2 motions to dismiss in this case, which I overcame. I was surprised that I did not overcome this motion for summary judgment. To have to go back and face another summary judgment motion, again, no, that is nothing I would be looking forward to.
I don't think we're on the same page.
Maybe we're not.
I'm sorry. And I don't want to belabor the point. So go ahead, just go with your.
No, my position is that I think that you have 2 bases upon which to reverse the entirety of the judgment. On 4 causes of action which no motion was made and no threshold showing was made. I think, yes, you would say, no, these cases that didn't meet the threshold issue, those go back to trial. On the issue of whether or not the breach of contract was properly granted or not, I think you have to decide that on the merits. The merits is there conflicting evidence? Could a jury come to a reasonably different conclusion? No, we reverse on that too. We send that back. It all goes back for trial.
And counsel, you have just over 4 minutes remaining.
Well, unless the panel has any further questions, I'd like to reserve that remaining 4 minutes. Thank you.
Please, the court. Good morning. My name is Ken Frankel. I represent the appellees, Tony DiBenedetto and David DiBenedetto. The first thing I'd like to point out to the court is that the deposition of Jack Bassey was filed with the court on February 28, 2014, as appears by the docket. And also, in answer to a question raised by the court, depositions of David DiBenedetto, Tony DiBenedetto, and Rose Simon were filed with the court on October 28, 2013, as appears by the docket.
Is this all prior to the granting of summary judgment?
Oh, yes, Your Honor.
Thank you.
Yes, Your Honor.
And you referred to those depositions in your motion for summary judgment as evidence of why there was no issue of material fact?
Yes, Your Honor. In fact, Jack Bassey clearly stated in his deposition, and I went through that colloquy on the brief, that Jack Bassey's opinion, the contract at issue was between All-Type and Sparky Development. And that's the issue. I do represent Sparky Development in this case, and we're obviously not here arguing the merits of the case. Sparky does not concede liability or damages, but clearly this case should be between All-Type Demolition and Sparky Development.
But your breach of contract was the only thing.
No, I disagree with that, Your Honor. The motions for summary judgment were directed to the complaint, the entirety of the complaint. The motion for neither motion for summary judgment specifically addressed a specific cause of action. The motion says asking for summary. The motion's asking for summary judgment on plaintiff's complaint. Interestingly enough, the opposition to the summary judgment motions was a shifting sands approach. There was an argument made because of this one sentence in the contract, which in the context of the contract makes absolutely no sense. It mentions 3 names: Joseph Bassey, David DiBenedetto, and Tony DiBenedetto. And All-Type makes much of this, saying that, well, this is why the contract is with Tony and David. But if that's the case, then the contract would be between Joseph Bassey, Tony DiBenedetto, and David DiBenedetto. All-Type wouldn't even have standing to sue because they wouldn't be a part of the contract. All-Type can't have it both ways and say, well, the contract says it's between All-Type and Sparky, but this one sentence says Joseph Bassey, Tony DiBenedetto, David DiBenedetto, so therefore Tony and David are parties, but not Joseph, but All-Type is, but not Sparky. Clearly, in reading the entirety of the contract, the contract is between All-Type and Sparky. An entity can't sign a contract, obviously, and David DiBenedetto signed on behalf of Sparky. And this is,
And what did the contract say?
In which contract? Because he's arguing it was an oral contract, and
Well-
you got two written contracts.
well, this is also part of the shifting stance approach, that this oral agreement comes out of thin air. In fact, the complaint alleges in paragraph 13 of the complaint that there were no other contracts. So
Well,
now,
during the pendency of that contract,
pardon me?
during the pendency of that contract, an argument could be made.
Well,
I mean, you know, if a contract expires, it's no longer effective, then it's not gonna bind you to enter into a new contract. That's what you did with the second contract.
well, but the contract didn't expire. And-
Well, why did you feel the necessity to do a second contract?
Well, there was a first written contract and there was a second written
But
contract.
I'm sure the same language was in the first written contract, wasn't it? There are no other contracts?
Essentially, there might have been some differences.
So the second contract was void too?
No, the second contract wasn't void. The second contract is the contract upon which the complaint is based.
I was just going with your theory that since it had language in there that there was no other contracts or no other agreements between the parties, then you had a second contract. That's
No, the complaint alleges the second contract as the contract of the parties. And the complaint says that in paragraph 13, there are no other contracts. So we're talking about the contract that's attached to plaintiff's complaint, which was written contract number 2.
I understand that. I was just meaning since you had said there was a first contract, it also said the same thing, that there's no other contracts.
No, it was the complaint that said that, not the contract. I'm sorry if the court
The
misunderstood.
complaint said there was no other contract.
Right, paragraph 13 of the complaint.
Oh, so it wasn't in the written contract.
The complaint is based on the written contract,
Second one.
the second one. And the paragraph 13, I believe it's paragraph 13 of the complaint, states there are no other contracts. Now, all of a sudden, out of thin air, we're talking about another contract,
Oral contract.
an oral contract. But even assuming arguendo,
That was written.
that occurred, clearly, any discussions with David DiBenedetto were in his capacity as the representative of Sparky, not David personally. And on that subject, with respect to Tony DiBenedetto, Tony DiBenedetto did not sign any contract. In fact, Jack Vassey's affidavit stated he had only negotiations with David DiBenedetto. So with respect to Tony, it's baffling how Tony could possibly be a part of this since he didn't sign a written contract and had no discussions with this out of thin air oral contract. With respect to the other causes of action, the reason why the court granted summary judgment, and this is obviously a presumption, there can't be, if there was a promissory estoppel, it again would have to be on behalf of Sparky. And again, Sparky doesn't concede that there's liability on promissory estoppel, but any conversations about this contract were in David DiBenedetto's capacity as a representative of Sparky.
And is that what you argued in summary judgment as to why promissory estoppel was not effective?
It wasn't specifically addressed because, but the argument in the summary judgment was essentially this lawsuit should be between All-Type and Sparky Development. That's who Sparky Development owned the shopping center. David DiBenedetto clearly was in his representative capacity in his negotiations with All-Type. Clearly, any cause of action that All-Type asserts would only be against Sparky, and that's why Sparky didn't file summary judgment, because clearly there are factual issues. Sparky denies certain things that are asserted by All-Type, so it would have been absolutely a waste of the court's time for Sparky to file a summary judgment motion. There's too many factual disputes on the merits of the case. But the merits of the case are between Sparky and All-Type.
Here's a question. On the order that the court issued, the order says defendant David DiBenedetto's motion for summary judgment was granted. What about Tony? Did Tony make a motion for summary judgment?
Yes.
Was that granted as well?
Yes, it was.
Was this under separate entry?
Yes, it was. And I believe those entries are attached to briefs, I believe. Yes, so certainly attached to my
Tony and David are both out, according to the.
Right.
entries here.
Right. And this case should be between All-Type and Sparky. Another issue I'd like to address is there's much reliance on Kitty Mez's affidavit. She consistently states, I was informed, I was told, I was informed, Jack told me, I was informed. Her affidavit is not based on personal knowledge. And I think that's why the trial court gave it no weight, because...
How do we know that?
I don't know the court gave it no weight. Well, the court granted the summary judgment motion.
I know, but there's nothing in the court's entry about anything.
No, well, the court didn't specifically state anything about
Didn't
that.
talk about anything, just that summary judgment was granted, basically.
Right.
So how do we know anything?
Well, unfortunately, the litigant can't control what the trial court
I know, I'm not picking on
says.
you with that, it's just that seems to be the running mantra or whatever the courts do now, it's just summary judgment granted, summary judgment, that's it.
No.
And it's hard to review, you have nothing to review.
Well, I guess that's why we're here now, to review it. But again, affidavits...
And that's not your fault at all, I'm just trying to figure out how we're supposed to do some of these things sometimes.
Well, affidavits should be made on personal knowledge.
But did you file a motion to strike in regard to that?
No, I didn't file, no, neither Tony nor David DiBenedetto filed a motion to strike the affidavit of Kitty Mez's, but I don't think either Tony or David felt that was necessary procedurally. The court can look at evidence or proposed evidence in any way the court wants to. I don't think, for example, in a trial, if you make an objection, you don't necessarily have to make an objection at motion to strike the statement. The court sustains the objection, that's satisfactory. With respect to the spoliation, that allegation, that wasn't assigned as an error. So if this court were inclined to reverse this case, that wasn't assigned as error, so that should be affirmed. It wasn't appealed. There's also an issue of the timeliness of this appeal. The trial court made a non-pro-tunc entry roughly, I think, well, I don't want to give the dates because I don't have it in front of me, but sometime after the appeal time, making a no just reason for delay entry.
Well, how is there an appeal time if it wasn't a final appeal order?
Well, it wasn't a final appeal order, certainly until the non-pro-tunc entry. However, it is David and Tony's position that a non-pro-tunc entry can't extend the time to file an appeal. And if it's a now for then entry, the appeal time should run from the time of the original judgment. And clearly the appeal was not timely filed from the judgment granting summary judgment, which would mean that this appeal should be dismissed as being untimely filed.
Well, what your argument is, I think, if I understand you correctly, is since it technically wasn't the procedures that should be used to put 54B language on a summary judgment motion, enough per time. It's not enough per time, basically. It's not enough per time. You're saying that the judge, enough per time would be either a clerical error or, to reflect what the court did at the time, and you're saying the court had no intention of making it having 54B language on there.
Well, it's hard to...
I know, it's hard to wrap your head around it.
I don't want to be presumptuous of the trial court's intentions, but the court speaks through its journal, and the journal says not pro-tunc.
So what should the court have done in order to make it appealable?
At the time of the granting of the summary judgment, make a 54B determination.
Well, and that doesn't happen a lot of times, and courts will go back and then add 54B language, but you're saying they shouldn't have done it through a non-pro-tunc.
Well, I think by the trial courts doing it through a non-pro-tunc, it did not extend the appeal time.
It could have just reissued the summary judgment motion and
Trial court could have.
the summary judgment ruling and put 54B language on it.
That is correct, but in fact, the trial court didn't do that.
Would you agree there has to be some mechanism
Oh, yeah, there's got to be some mechanism, but the mechanism that was used,
That's the wrong one.
what Tony and David respectfully suggest, does not extend the appeal time.
So you're suggesting that the May 14th granting of the summary judgment, that was the time that should have started the clock ticking?
Correct. Which would have been, I think, June 13 would have been the last day of the time we filed an appeal. And the non-proton entry came after that, sometime. With respect to the fraudulent conveyance allegation, again, you have to be a debtor to a creditor. And if the trial court determined that Tony and David were not in the case, then they can't be a debtor to a creditor. Only Sparky could be a debtor to a potential creditor. So that's why that cause of action would be part of the summary judgment. And again, even though the All-Type suggests that there was only one cause of action that Tony and David moved for on summary judgment, the record indicates that both Tony and David asked for summary judgment on the complaint. They didn't ask it on first cause of action, second cause of action, or any cause of action. They said on the complaint. And the trial court granted the summary judgment on the complaint. I don't have any further comments unless the court has questions. Thank you, Your Honor.
First, let me state my embarrassment having missed the docket entries that said that the depositions were filed. But I do not think that changes anything whether or not they were filed or not. The fact of the matter is that the defendants in this case did not file the Rule 56G motion to strike. The Supreme Court has pretty solemnly held and unequivocally held that in Bird v. Smith, which cited in the brief, that unless a motion to strike has been filed and granted, those affidavits should be considered. We've also cited case law in our brief that establishes that if the affiant attests that the contents of her affidavit is to her personal knowledge, then unless there is a finding that it is not to her personal knowledge, that is to be accepted. And they did not contest that at the time or put up any evidence to show why her knowledge of the contents of her affidavit was not based on personal knowledge.
Well, can't you look at her affidavit, based on what's being alleged, and understand that it's not...
I think where she relied on comments from other individuals, absolutely. You take the affidavit for what it says, but then there's no ruling. Again, no ruling to strike that portion is not according to hearsay, and he had an obligation to raise that issue, and he didn't raise that issue. So again, I think the court has to take that affidavit at its face value. The other thing is, you made much of Sparky versus the DiBenedetto brothers. They're one and the same, okay? Sparky Development is just one of a half dozen companies that the DiBenedetto brothers have in use. So, it's not like this should be against Sparky, this should be against DiBenedetto's. You don't know who you're dealing with. In this particular case, following up what you said, Your Honor, yeah, and I think that's been my complaint all along. There were certain things this trial court should have done and it did not do. You ask, how do you correct that? Well, I think you follow the stringent and rigid rules and requirements of Rule 56. And that if those aren't met, if the movement does not establish the initial threshold, then as the courts have held from Drescher since, summary judgment must be denied. They must meet that threshold firsthand.
But if the non-proton was inappropriately used, we may not have a final bill of order.
Well, Your Honor, I think no proton was an unfortunate use, and I think it was a clerical error, and I think that's why God made Rule 60A, because the summary judgment ruling by Rule 54 was not a final appealable order until all claims against all parties were resolved, or until such time as the court made a finding of no just reason for delay. We know the court did not do that until some time later. The court unfortunately used the Latin term for now, for then. That, in either event, that is an interlocutory order until the court says, I find no just reason for delay. And Rule 68 permits the court to go back and visit and revisit its interlocutory orders up until the time it becomes final. So, do I like the court's language, use of the language, no proto? No, I do not.
So we, even though the court says it's a non-court time, we just,
I think you have to read that order in the context of what the motion asked for and in the context of what actually happened. Does a no proton order make any sense? It really is an additional substantive finding. It may call itself a no proton order, but it is not, as I think you pointed out, a no proton order. It makes a substantive finding it had not made back in May of the year.
You did make it as a final order. You just asked for delay. So
Yes, and that is a substantive finding, that it had not made. It was not fixing a clerical error at that time. So I think you have to take the order and look at it as a whole and say, well, it really isn't what it says to be. What it is this.
And counsel, I think you did inform me that you've reached the end of your allotted time for today.
Thank you very much.
Thank you both for your presentations. This morning, the court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Thank you.